Welcome to Jailhouse Law. I'm Aaron, your jailhouse lawyer of 15 years. What's your jailhouse lawyer, you ask? Let me explain. I am not a licensed or practicing attorney. As a jailhouse lawyer, I'm an individual who, while incarcerated, conducted legal research and provided informal assistance to other incarcerated individuals. Additionally, I conducted my own legal research and represented myself as a pro se litigant, both in and outside of prison. Last week, there was a leak from the United States Supreme Court concerning the upcoming decision in Dobbs v. Jackson Women's Health Organization. It's a decision that has the potential to impact Roe v. Wade and Planned Parenthood versus Casey. And based on what the draft said, it appears likely that both of those cases will soon be overturned. I want to address the upcoming decision, but first I want to clear up some common misperceptions regarding Roe and Casey. Firstly, I want to address the misperception that Roe provided an unlimited right to abortion. It did not. And to check that out, let's actually take a look at the case. On the basis of elements such as these, if you see the highlighted portion, on the basis of elements such as these, appellant and some amici argue that a woman's right is absolute and she's entitled to terminate her pregnancy at whatever time, in whatever way, and for whatever reason she alone chooses. With this, we do not agree. So this is the Roe court establishing that they do not think it's a woman's right to terminate the pregnancy at any time. So even though Roe established a right to terminate the pregnancy, they put limitations on it. And so if you look here at this portion, it says, "We therefore conclude that the right of personal privacy includes the abortion decision, but this right is not unqualified and must be considered against important state interest in regulation. After viability, the state can actually come in and prohibit abortion." Here it says, "With respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has both logical and biological justifications. If the state is interested in protecting fetal life after viability, it may go so far as to proscribe abortion." That's one of the key points I think people need to understand, because they may not realize that even Roe v. Wade puts limitations on abortion. The principle that people think is operating and is effective based on Roe v. Wade. A lot of people think that Roe v. Wade is the Supreme Court acceptance of the principle of my body, my choice. That is also a misconception. So if we look back at Roe, at the bottom of the bottom highlighted portion, it says, "The privacy right involved, therefore, cannot be said to be absolute. In fact, it is not clear to us that the claim asserted by some amici is one that one has an unlimited right to do with one's body as one pleases bears a close relationship to the right of privacy previously articulated in the court's decision. The court has refused to recognize an unlimited right of this kind in the past." Then it cites Jacobson v. Massachusetts, which is a case that you may have heard of recently regarding vaccination. And the reason why you may have heard it lately, because last year when people were talking about instituting vaccine mandates, this is the case that many were pointing to say, hey, it's constitutional. It's completely allowed. The government, the United States government, has implemented and has established that it has the right to override our personal decisions over our bodies in cases it deems necessary. And so it's very interesting that this case, Jacobson v. Massachusetts, at the time when we're looking at actual vaccine mandates being implemented across the country, was brought back into the public consciousness at the same time as there is an attempt, and it looks like a successful attempt, to roll back the scope of the abortion rights afforded by Roe v. Wade. But there's a couple of other things. There were a couple of other things I want to take a look at. So Casey doubled down on the state's power to restrict abortions. And if we take a look at it here, it says that the Casey case reaffirmed several things from the Roe v. Wade case. One of those things is that it recognizes a woman's right to choose to have an abortion before fetal viability, and to obtain it without undue interference from the states whose pre-viability interests are not strong enough to support an abortion prohibition or the imposition of substantial obstacles. The second point is what's key here. A confirmation of the state's power to restrict abortions after viability if the law contains exceptions for pregnancies endangering a woman's life or health. So the Casey case doubled down on the state's power to say once a fetus is viable, the government has the authority to stop and prohibit abortions. Now, if we look at the last thing I wanted to point out from the Casey case, Casey doubled down on that the state has an interest in protecting the health of the woman and the life of the fetus. This is important because a lot of people think that in Roe and Casey, the government established that a fetus wasn't alive. That's not accurate. So if we look here, it says the principle that the third point, the principle that the state has legitimate interest from the outset of pregnancy, and that's key, from the outset of pregnancy in protecting the health of the woman and the life of the fetus that may become a child. So these are just a couple of things I wanted to point out about these cases before we take a look at the draft decision, which will likely go through some changes, but it does appear that that's going to be the ultimate decision. The question is, what parts and portions are going to remain in the final draft, and what's actually going to be removed. But I think it's a really great idea for us to just take a look at where the current law is that's about to change, just so that we could further understand and better understand the reality of where we are and where we've been before this new decision comes out. We're going to take a look at the draft opinion to figure out where the court is headed. If we look at their discussion of Roe v. Wade, where they talk about how Roe created these separate regulatory schemes for each trimester, and that the government, and indicated that the government had different power and more power at different aspects of the pregnancy. So in the last trimester, the government had enough power to prohibit abortion. And it also acknowledged that from the outset, the states had the interest in protecting the potential life from the outset of the pregnancy, the potential life of the fetus. And if you look at this section, they talked about Casey and how even though Casey upheld certain key portions of Roe, it rebuked the underlying reasoning of Roe and it moved away from that reasoning. So they're using Planned Parenthood versus Casey as grounds to undermine Roe. And this is a key point because at this point, Alito mentions the right to privacy, and he mentions how this was part of the reliance of Roe, but he states that the Constitution does not actually recognize the right to privacy. That will have implications far outside of this case. In this point, he talks about Casey's description of the freedom to make intimate personal choices and of bodily autonomy. And I said it last year that the left's embrace of these mandates, especially at this time, severely undermined their ability to challenge what was coming. They knew what was coming, and they still embraced these mandates, and they themselves have undermined the principle of bodily autonomy to the point that now they cannot mount a defense in order to protect Roe v. Wade or Casey. I consider myself pro-choice, and here he's talking about embracing the idea of bodily autonomy can lead to other things. And I'm like, yes, that's the point. And if we're going to be pro-choice, if somebody's going to be pro-choice, then that just doesn't mean that a person has the right to choose whether or not they want a jab. That doesn't just mean that the person has a right to choose whether or not they want to terminate a pregnancy. That also means that person has the right to determine whether or not what they want to put in their body, whether it's drugs or whatever, whether or not they want to engage in prostitution. These are all choices that individuals should have over their own bodies if you believe in being pro-choice. If you're actually pro-choice, this is what you should believe. This is what you believe if you're pro-choice. But if you're arguing that certain things, people shouldn't be able to make certain decisions, then you're undermining the ability for individuals to make their own decisions in other areas as well. He talks about stare decisis and the fact that even though it means to stand by things decided, it's not a infallible principle, and it's at its weakest when you're dealing with constitutional issues wrongly decided. And he cites several different cases, including Plessy v. Ferguson, which was overturned by Brown versus Board of Education because it was violative of the Constitution. And I'd like to thank you for checking out this episode of Jailhouse Law. As always, don't forget to give the thumbs up, like, share, subscribe, comment in the section what you think about this case, what you think about my analysis. Also, what cases would you like me to talk about? What kind of legal concepts are you interested in hearing about? Share all that stuff in the comment section below, and I'll address it either in the comment section or in future videos. And I'll see you next time. Okay, so that's it.